Judge Sarah Netburn will have to determine if Andrea Fox, the accountant for the SEC Enforcement Division, testified in summary form or as an expert. Judge Netburn also has to determine if the material she's providing and her testimony are new expert testimony or a summary of previously given testimony. The language in the SEC's opening brief about post-complaint accounts will be disregarded by the court if Judge Netburn grants the motion to strike. The SEC's argument for a punitive disgorgement and injunction may be impacted if Ripple wins. On May 6th, the SEC is required to submit a reply brief in addition to the briefs regarding the motion to strike. The remedy-related brief filings conclude with the reply brief. On March 22, the SEC submitted its opening brief, and on April 22, Ripple filed its rebuttal brief. Investors will have no trial to consider, so until a court rules on Ripple's punishment for breaking us securities laws, XRP and Ripple are in the dark. However, by appealing the programmatic sales of XRP order, the SEC is likely to drag the case into 2025. The third component of the Howey test is not satisfied by programmatic sales of XRP, according to a July 2023 ruling by Judge Annalisa Torres. An ongoing obstacle for XRP is the possibility that the SEC will file an appeal of the programmatic sales judgment. Activity in the SEC vs. Coinbase Kings pick up steam as the case involving Ripple gets closer to the deliberation stage. Senate runner John E. Ditson and crypto lawyers take on the SEC versus Coinbase case. Johnny Deaton, the founder of Crypto Law Us and a candidate for the U.S. Senate, filed an amicus curiae brief on behalf of 4,000 Coinbase users on Friday, April 26. The Coinbase motion to seek an interlocutory appeal against the decision on the Coinbase motion to dismiss is supported by the amicus curiae brief. The motion to dismiss the charges for operating as an unregistered securities exchange was dismissed by Judge Catherine Fulla in March. The preliminary statement referred to the SEC's argument to file an interlocutory appeal to challenge the programmatic sales of XRP ruling, as well as the SEC v. Ripple lawsuit. Legal clarification in the United States is desperately needed by the cryptocurrency industry, particularly Coinbase customers. Nearly everyone agrees, even the SEC in the Ripple case. The SEC states that a valid reason for a disagreement justifies an interlocutory appeal. The SEC's request to initiate an interlocutory appeal against the programmatic sales of XRP judgment was denied by Judge Annalisa Torres in October. The U.S. digital asset market may be significantly impacted by the resolution of the CC. Coinbase lawsuit. If Coinbase wins, the SEC regulatory hegemony could be challenged through enforcement. Additionally, a victory might put an end to the SEC's efforts to appeal the programmatic sales of XRP ruling. Prominent XRP advocate and attorney John Deaton has delivered a stinging critique of Chairman Gary Gensler of the Securities and Exchange Commission in a scathing attack. He charged that Gensler was infecting the entire agency and upholding bad faith regulations. Attorney John Deaton of XRP criticizes SEC Chair Gary Gensler. Deaton vented his annoyance on social media networks X. With all due respect, it is time to serve multiple subpoenas to the SEC and Gary Gensler. He said, to further clarify the situation, he cited his amicus brief in the Coinbase v. SEC lawsuit. In its motion to strike, Ripple asked the court to reject the testimony of SEC accountant Andrea Fox, as well as the accompanying documents known as the Fox Declaration. The SEC opposition brief begins with a noteworthy distinction. It categorized Andrea Fox as a summary witness and stated that Ripple falsely asserts that this statement is unreported expert testimony. It doesn't. It is conventional summary evidence that can be used to support disgorgement estimates under Fed, R-Evid. 1006, it is not a report written by an expert. It does not draw from specific experience, and it offers no opinions at all, much less one that is considered to be expert. Furthermore, it does not include the evidence of an eyewitness. Instead, it streamlines the evidence presentation to Judge Torres by performing simple math on Ripple's financial data. It matters whether Andrea Fox is a summary witness or an expert. Ripple contended in the motion to dismiss that Fox could not provide fresh information because the SEC had declared him to be a summary witness rather than an expert witness. During discovery, the identities, testimonies, and evidence of expert witnesses must be made public by the SEC. By this Thursday, May 2, Ripple must submit its response to the opposition brief. If there were any new exhibits or information in the Fox Declaration, it may be the main topic of the reply brief. Furthermore, Ripple may contend that Andrea Fox qualifies as an expert witness If the SEC failed to comply with the standards for discovery, Ripple would have a basis for a motion to strike. Andrea Fox works in the SEC Enforcement Division as an accountant. Securities laws and SEC's reply brief filing the SEC has until May 6th to submit a reply brief to a Ripple opposition brief following the filing of the Ripple reply brief about the motion to strike. The papers are related to the opening brief filed by the SEC, in which the SEC requested an injunction and punitive punishment from the court for violating a securities laws. After the December 2020 complaint, the CC claimed that Ripple kept breaking a securities laws post-complaint. Ripple claimed in the opposing brief that it only allowed old transactions for post-complaint XRP sales. The ODL contract stopped gains and shield buyers from losses. Ripple further claimed that it made sure its institutional investors met the requirements to be considered accredited investors. Under US securities rules, sales to accredited investors are excluded. Although investors should pay attention to the verdict on the motion to strike, the outcome of the Ripple case will be more important. XRP may be impacted by a penalty, disgorgement, and an order that forbids Ripple from selling XRP to institutional investors. The main focus, meanwhile, continues to be the SEC's plans to appeal the programmatic sales of XRP order. The third component of the Howey test is not satisfied by programmatic sales of XRP, according to a July 2023 ruling by Judge Annalisa Torres. If cryptocurrency is deemed a security by a different court decision, the SEC would have additional legal grounds to regulate the cryptocurrency market. Judge Rakoff declared in December that Do Kwon and Terraform Labs had neglected to register Luna and Terraust as securities. Judge Fowler rejected Coinbase's H1 motion to dismiss MTD accusations against it for conducting business as an unregistered securities exchange in March. Coinbase submitted a motion to appeal the decision interlocutorily. I urge everyone to read the amicus brief I filed in the Coinbase case. He continued, the brief has a portion that demonstrates Gensler is an agency-wide bad faith regulator. Following remarks made by House Financial Services Committee Chairman Patrick Machinery on the current lawsuit between Consensus and the SEC, this criticism has been made just months after a federal judge sanctioned SEC enforcement lawyers for lying to the court. New evidence shows Chair Gensler himself misled Congress, declared McHenry without holding back. Furthermore, McHenry emphasized Gensler's hearing before the Financial Services Committee in April of last year, during which he declined to respond to questions about the SEC's Ethereum classification. Gensler's silence, according to the HFS's chairman, was an intentional attempt to distort the commission's position. He underlined saying classifying Ether as security contradicts previous statements made by Chair Gensler in the SEC. Yet another illustration of the arbitrarily and capriciously applied enforcement approach to digital asset regulation by the agency. Fundamentally, the Consensus complaint asked the SEC to formally recognize Ethereum as a non-security, but the situation is exacerbated by the SEC's previous position, which leaves the regulatory body potentially in contradiction with itself.